Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Our partners are experienced trial attorneys who have been board certified in family law by the Texas Board of Legal Specialization.
Thanks for tuning into the For Better, Worse, or Divorce podcast, where we provide you tips and insights on how to navigate divorce and child custody situations. I'm Brian Walters. I'm joined by my partner, Jake Gilbreath, and today we'll be discussing practical ways to keep your legal fees and other divorce-related costs under control, as well as some strategies that we found that can help you protect your finances while achieving the best possible outcome during a divorce. I'll start off with two things. One is that I get asked this in almost every intake that I do or consultation. How much is this going to cost, right? Is that right? What you find too, Jake?
It's almost the first. Well, it's usually not the first question, but it's what they want to ask for the first question.
Of course, yeah. So you like me, I typically proactively just bring it up because I know everybody's thinking about it, even if they're, seemingly don't have any financial limits. Everybody's interested in it. So it's a real good question. Secondly, I think just to flesh this out a little bit, there are kind of two major types of cost. One are the legal fees that are paid to the law firm for legal services. And the other, well, there's really three. Then there's fees that in some cases you'll need to pay to experts who are going to value a business or trace a separate property claim or something like that. And then there's other things I call kind of out-of-pocket cost, and that's things like copies, or similar type of things. But for most people, in most cases, the legal fees are the largest single item. There's a particular strata of cases that the expert fees are very significant and sometimes even more than the legal fees, but that's generally a pretty narrow type of case. So we'll get into that all. I just wanted to say those two things to preface this with. And I guess one last thing is the biggest driver of cost is the conflict in a case, but there's a lot of details below that. Of course, as I just said, the attorney fees are usually the largest single line item. So hiring the right attorney is going to make a difference, both in the outcome of the case, but also the cost of the case. So I'm not sure there's a huge difference in every case about the lawyer's total fees. I think that we're very efficient. We try to communicate with clients well and try to come in under the cost of the other law firm. And I'll let you talk about that in a second. I know that's something you and I have spoken about a lot, but one of the things that I see very frequently is just very poor organized accounting and billing systems. I repeatedly talk to clients who are new clients who have gotten rid of their old law firm. They don't get bills very often. They don't know how much they owe. They don't know how much they have in trust. They can't figure out the bills that they get. And so I think that's important to ask your lawyer. How often do you bill me? What do the bills look like? How will I get questions answered, or how will I understand what's going on? Because honestly, it's confusing with trust accounting. It needs to be clearly stated. So I think that's important. That's something we really pay attention to and have spent a lot of time over the years trying to get correct. Do you want to talk, Jake, a little bit about how we try to keep costs down with the way we interact with our clients?
Yeah, just to close the loop on the billing thing, though, I mean, it really is bananas how many law firms out there. I would probably say it's a majority of law firms out there don't bill on a schedule. I think the owners just kind of, when I have time, I'll have my accounting department send bills. I've seen clients go months without getting a bill, or they get bills sporadically and stuff like that. It's like, first of all, that's poor communication with your client. Also keeps the client in the dark about what's going on with my case. I know I'm being billed for this. What are y'all doing and charging money for me? So it impedes the client's ability to ask questions if they're not getting regular bills. And frankly, it's kind of a passive aggressive move by the lawyer to not send a regular bill, but rather just wait a few months and then send it and say, well, that's what you owe. So there's your bill, and it's way past the point of discussion. And so it is what it is. And to the extent that you're upset, well, I already charged you for it all, and so you can't really do anything about it. So we bill on a calendar. I believe it's the second, fourth Wednesday of every single month, just like your credit card bill. I mean, can you imagine your credit card company just randomly sending you a bill and saying, well, now you owe Amex this much money. We decided to send this bill and wait a few months, and now you owe this much to us. It's crazy, but a lot of people do it. But yeah, as far as what we do to sort of reduce costs, because this is something we've talked about in the podcast, and Brian, I know you and I have talked about it a lot. We've talked about it internally because we have discussions about rates, and we're very open about our rates. We post our rates on our website. They are not low rates. They are high rates. They're commensurate with the skill set that we have. But we are not shy about the fact that our rates are high by comparison. They're on the higher range of things, right? No different than, certain vehicles are on the high range of cost. Our rates are the high range. Having said that, what's really fascinating to me, and again, we've talked about this, is we are consistently, and I mean consistently, outbilled by the other side with lower rates. I think a lot goes into that. A lot of it has to do with efficiency. We are, we're that law firm we leverage technology. We're paperless. We're on Slack, or for those of you who don't know Slack, it's a lot like Microsoft Teams. Like we communicate in a really efficient way. That's one. I think, Brian, you and our level of experience, even with obviously comes with a higher rate, but in a lot of ways that reduces costs, right? Because something that maybe a lower rate lawyer without the level of experience that we have may take longer to prepare for something or longer to understand an issue or research an issue, as opposed to, you and I with our level of experience, and we're board certified in family law, just like all our partners are board certified. We should, in theory, come to the answer a lot quicker than somebody with less experience at a lower rate, right? So, yeah, you may get a lower rate with somebody, but they're going to take a lot longer figuring something out, or they may not get the answer. And so, yes, there's a higher rate, but with our years of experience, a lot of times it takes us less time to come up with a solution. I will say, to brag on our staff too, the way that we handle our cases, even cases, if you think about a case in our office where maybe Brian's on it, he's who you want as your lead lawyer, and Brian's got a high rate and very good, very experienced. We have really good and really experienced associates working on the case with Brian, or if I'm on the case working with me, that are working on this sort of at a lower rate, working on the day-to-day, moving the case forward, filing things, preparing for the hearing. And I brag all the time to people. It's like, my job is easy. The associates are out there doing a lot of the really hard work of organizing and getting us ready for a hearing, obviously with my direction, but working with the client, gathering exhibits. I have lots of hearings where I'm preparing, and we have a policy for everything. So there's an internal policy of when the associate needs to be prepared for the hearing. I have a lot of hearings where really the associate's presenting to me our preparation, our exhibits and everything. And my job is to look at it and say, really good job. We're ready to go. And obviously we're meeting with the client and all those sort of things, but they do a lot of really good work. A lot of times in the background, right? And I kind of brag on them and say a lot of my job is sort of sweeping in at the end and kind of taking the credit and running with this really, really solid preparation that they've done. And that saves money. And then last, I'll say, on our favorite topic on this podcast is communication really is imperative when it comes to keeping costs down. I tell clients at the beginning all the time, ironically, you save money by a lot of communication with your lawyer and a lot of information to your lawyer. If you can't get a hold of me, and then I don't know what's going on with your case, and then all of a sudden I have to prepare for your hearing or prepare for your mediation, not knowing what's going on, that's going to be really inefficient. On the flip side, right, the client's not communicating with us, and my office is having to call you to beg you to provide your bank statements or provide the text messages that the other side's asking for, the tax returns, whatever. That's inefficient, right? And so right off the bat, we're stressing communication with the client both ways. We're stressing technology in ways that information can be shared in an efficient way. And all that helps with the cost. And I think that's why we ultimately see, we're not shy about it, we're not cheap. Now, this is not a cheap process. This is not an inexpensive process. but we are really proud of the product that we give. And a lot of times we're outbilled by a less good. Is that a less good product? And I don't want to say inferior, but I'll say inferior product on the other side that gets charged more than what we're providing.
All right. I think the next biggest driver of expenses is one I kind of mentioned before, which is the conflict level. And what that's ultimately reflected in is how is this case going to be resolved? How are we going to settle it, usually through mediation, or is it going to go to a trial, to a judge or a jury? Which kind of harkens back to communication, right? Like we need to know exactly how you want us to handle the case, what your goals are. Are they set in stone? Are they flexible? That type of thing. And you can achieve different things through different routes, right? The vast majority of cases in the entire American legal system, criminal, civil, federal, state, whatever, all rely on settlement of most cases, or else the courts would be completely overwhelmed. And that's still what happens in family law. But and so if you do that, if you and your spouse, for example, or get everything together, tell your lawyers, look, we want to work this out. We don't see eye to eye, but it's not, our differences are not that great. Then we know to do that and not build the case up to be difficult. And we know to get to mediation, and there's going to be compromise, but it's going to be done. Everybody's going to be able to move on with their lives. If it's going to go the other way, if it's going to go to litigation, it's going to be both longer and much more expensive. Litigation is just is. There's no two ways about it. That's part of the system we have. You're entitled to a court, your day in court if you want it, but essentially you're going to pay for it. And that's usually enough of a disincentive for most people to decide to settle it. So that is certainly going to drive things. I think it matters to some extent if we're going to mediation, which mediator we choose, how long we go for the mediation, and being prepared for it. Do you want to talk a little bit about choosing a mediator and being prepared?
Yeah, I mean, it's obviously if we're going to spend the money and time and effort going to mediation, which most cases, like you said, Brian, settle in court. Everybody wants their case to settle, right? I tell people all the time, only crazy people want to go to court. But sometimes you don't have an option, given the circumstances or the positions the other side's taking. But we always want to settle. And so knowing the mediators in town, in the area that you're at, knowing who's some cases, the particular personalities involved, you just know that one mediator is going to be more successful than the other, and having that level of experience rather than just kind of picking out of thin air the next mediator that's available increases the odds that you're going to have a successful mediation. And preparation is you almost prepare for mediation more than you prepare for court. There's a mediator in Travis County, Kathleen Coble, really good mediator, and she and I have done presentations to the family law section at Advanced Family Law, talking about mediation and litigation. And Kathleen makes a really good point, and she says, as a mediator, and Kathleen's a full-time mediator, Kathleen says that mediation is often the most important day in the client's case for certain. Sometimes it's one of the most important days of their life, is their day of mediation. And routinely we see lawyers showing up unprepared for mediation, thinking, well, I'll just have the discussion with my client in the first few hours of mediation. Well, a few problems with that, right? How stressful is that? You're showing up, it's like showing up for your surgery and the doctor telling you what they're going to be doing the morning of, what operation you're having. That's stressful. It's incredibly inefficient, because we're all sitting around waiting for you to explain to your client what mediation is and what offers you're going to make and what to expect. That's inefficient. And it just leads to poor decision making, right? If everything's being dumped on you in a single day and you have to both intellectually and emotionally process it in the moment, it's going to lead for a really bad outcome. I will say that it doesn't necessarily mean that you're not going to settle. I see a lot of cases settle where we get the phone call after the fact that says, yeah, I settled my divorce, but it's a horrible settlement because my lawyer didn't prepare me for mediation. And then before I know it, it's 5 o'clock and everybody's screaming at me and saying I have to sign this. And so I signed it. What do? And unfortunately, the advice on that is you're stuck, right? You signed a mediated settlement agreement. So preparation is just key to have a good outcome, but it's also really it increases the likelihood that you're going to settle if you're prepared, and it's going to be a more cost-efficient way of going about it if you actually prepare for mediation and pick a good mediator.
Another way to reduce costs is basically make your lawyers or your experts' life easier. So, for example, let's say we have an issue where we represent the wife. She says her husband has got a serious enough drinking problem that it's not really safe for him to be around the kids regularly, young kids, let's say. Well, what are we going to hear from the dad in court? No, I don't. I have just a couple of beers while I'm watching a football game, or she drinks as much as I do, right? I mean, if you're in court, what's a judge supposed to think, right? They don't know either one of you. So you're inevitably, when you say that, we're going to be saying in return, okay, I need a timeline, kind of show us dates and times where particular things occurred. If you've got evidence, pictures, recordings, talks, witnesses who've seen him drunk, or whatever, text between the two of you the next day about, why, or, I really wish you wouldn't be drunk around the kids or whatever, then you're going to need those. So you might as well start getting that information together, because if you don't have it, that's called evidence. And if you don't have it, you're not going to get very far in a case with it. And your attorneys are inevitably going to ask for it. And the better you have it organized and the more ready you have, the easier it is for them. So that's one thing. Another one is in any divorce where there's money involved, you're inevitably going to get asked the same questions. What assets do you have? What debts? What about current statements? What about the past, probably the last year or two of statements? So getting that type of thing together ahead of time, or getting it organized once a case is started, is really helpful. I realize some people, their spouse deals with the money. They're not going to have much information, but even they often have, informations or bits and pieces of info or access to tax returns or things like that can be helpful. So you might as well start doing that. There's also, anytime you apply for like a loan or a mortgage or something like that, generally you and your spouse have to fill out a form that says, here are my assets and debts. And so if you've done that in the past couple of years, that's usually something real helpful to pull and summarize things, although those are not always accurate. So anyway, any other things that come to mind about being organized and proactive like that?
No, just I guess I'd add that we do our best to make it easy for clients, right? Again, leveraging technology. We're cloud-based. We have an interactive Google Doc that we share with clients. We, Google Drive and that we share with clients, and we do make it easy to share information. We're on Slack. We make it easy for clients to share information for us, because they're the ones living the life, right? Like, obviously they need to hear from us if this is the type of evidence we're looking for, but it's going to be on the client, and you want it to be on the client. You don't want me digging through your text messages at my hourly rate. What's in there. And so with our direction, having the client work in sort of a collaborative way with us is really a cost efficient way of moving forward.
Yeah. And the same thing is true with experts. If we have a child custody evaluator and the issue's alcohol, same thing. They're going to want the alcohol evidence. Same thing with the financial expert, let's say, who's going to value the business. If you're the business owner, get prepared to give your tax returns and current bank statements and P&Ls and everything else. So as you might expect. Well,
I was going to say, on the topic of financial experts, that may have been where you were going to turn to. That's another sort of another cost saving mechanism. Is there are some cases where there's just going to have to be an expert, right? There's a business that's going to have to be valued. There's separate property that's going to have to be traced. And I see clients all the time, and I see lawyers all the time kind of foot drag on spending that money, which I get, because it's, I don't want to go pay a $7,500 retainer for an expert to go value my business or trace my separate property or what have you. And people drag their feet just hoping against hope that, somehow the case magically settles without this crucial information being provided. And I see people spend a lot of money not spending the money that they need to spend in order to get their divorce resolved, right? They drag their feet on hiring an expert, or I've had cases where the lawyer hasn't told them until 6 months into the case, hey, by the way, we need to hire a financial expert. And then you haven't made the progress that you need to make because you haven't just hired the expert that we're going to have. And then you're 6 months into your divorce and just the process alone is expensive. And now you're going 6 months in, well, I can't get divorced because I don't have this expert. Fine, now we'll pay the money. Oh, now it's going to take 3 to 6 months for them to get done. So that's another 3 to 6 months of litigation. So it is an expense bringing an expert in. But I think all our lawyers are really good at letting a client know when it is going to be necessary to have an expert. A lot of times it's going to be a financial expert, but we have that conversation right off the bat, not 6 months into your divorce, that you need to get a financial expert. A lot of times we're having that conversation in the consult. Sometimes we get hired on cases. That's the first call before we've even filed a petition for divorce or whatever the pleading is that we're going to be filing. Is that we've made a phone call to the expert that we know we're going to need in the case.
Absolutely. One last topic I think is some common mistakes or issues that can really cause problems and make your case much more expensive. One is fighting over seemingly small assets or minor assets or issues. Now, the problem with that is that maybe they're not minor to you. It's maybe there's something with sentimental value. Maybe there's something that pets often fall into this category. Those are people have emotional attachment to pets. I do to mine. It's understandable. But just understand those things are going to those have a price on them ultimately. For example, the pets. I have had that issue come up. I want the dog. No, I want the dog. Okay. And well, I love the dog, or I spend most of the time with the dog, and that's totally understandable. But at some point it's going to come down to money. And so ultimately if you have that mindset, like, look, I really love this dog, but, I realize I could adopt another one. And, so I'm willing to let it go, or I'll take it for $10,000. I'll pay $10,000 to get this dog. I don't really care. I just want the dog. It's better to be upfront and clear about that, I think, from the beginning. But of course, sometimes I think what's going on with some certain items is that there's an attempt to have an emotional battle or issue that's camouflaged as a dispute over a sofa or a pet or whatever. That there's underlying emotional conflicts or unresolved issues, and we don't really have a way in our court system to resolve those. And at the end of the day, if you're getting divorced, you're looking at a property spreadsheet that's got a sofa or a dog on it, right? And so just understanding that about yourself and about what you're after and trying to understand what the other side's really getting at is probably the best way to achieve those things, rather than have a case blow up over something that to most outside observers would be seen as a smaller thing. Again, those are important things, and I'm not going to pretend like you shouldn't stand up for what you believe in, but that can often cause a problem. Is that something you've seen, Jake, before?
I had a case once the parties were separating and dividing up their items, and the police were called over a bucket, that they couldn't agree who was going to take the bucket. And it was a long marriage, and I don't think it was actually about the bucket that they were fighting about. So I get it, right? I mean, I've been through a divorce. I'm sure there's things that do matter. There's some things we're just in the moment, we're clinging on to, and it really is it's about something else. And it's sometimes hard, to be the bigger person in a divorce and walk away from the bucket, and say, fine, you can have the bucket. That can be really hard. And then, like you said, like with pets, maybe it is worth the fight, right? But the phrase I always use with my clients, or the advice I always give is, ultimately you're an adult and you can make the decision, right? My job is to give you advice. My job is to tell you what I think is going to happen in court. My job is to tell you how long it's going to take and how much it's going to cost. And then you take all that information, you process it, and you're an adult and you tell me what we're doing. But also please don't make me fight about the bucket.
And I think the last category is when someone tries to hide money or assets. And they fall into kind of two categories. One is where, let's say there's someone spending money on a boyfriend or girlfriend, or, sending money or giving money to family members or something like that. And they don't want the other side, they're embarrassed about it, or they don't want to piss the other side off, and they don't want to share that information. They don't want to give credit card, copies, or they've got a bunch of cash withdrawals. They don't want to discuss or give real clear meanings about where that went to. That's one category. You're not going to get away with that. You're going to have to open the books to the other side. And so you might as well just step up and take the blow. Now, there's a separate category of things like cash, jewelry, gold, things like that are difficult or impossible to really trace. That's kind of the purpose of them. Frequently, people often have things in safes or whatever, or in certain cultures, there's often jewelry given at a wedding that's kind of essentially a dowry, but it's not. There's no real record of it. Maybe some family members are holding it. Frankly, these things are very hard for a judge to figure out what happened. If there was $200,000 in cash in a safe, and one spouse says, no, there wasn't, and the other said, yes, there was, or one says the other person took it, no, they took it. It's very difficult for a judge to figure that out. And I mean, I'll be honest, those things sometimes just disappear without a clear answer. But if you're thinking of doing that to your spouse, they know what happened, right? Even if it's difficult to prove in a courtroom. And so if they know you ran off with $50,000 in gold and it's not showing up on the spreadsheet like that, they're going to take it out on you. They're going to make the case difficult. They're going to strive to get that $50,000 back one way or the other. And that is probably a short-sighted strategy that is going to cost you more money and time and stress than you like. And sometimes when you go to court, I've had this happen, the judge does believe, without super clear evidence, that one side or the other did run off with it and dings them. So then you've got the worst of both worlds if you did that. So I don't suggest that that's a good plan. I would try to be upfront and clear with your spouse or whomever that, we've got cash. Let's open the safe together. Let's each take half. Let's film it, and let's go about our business. You're going to have probably in the long run a better outcome than just having it in the short term and thinking you're going to get away with it. That's been my experience. So, any thoughts about that?
100% correct. Right. It's just you had that conversation with the lawyer, and being open with discovery on the other side, obviously within the bounds, is a really cost savings deal. And let me add this last one, Brian, on kind of common mistakes, because I know we've gone long or longer than typical on this, but this is just a pet peeve of mine. It is expensive when you have a lawyer or lawyers where the lawyers are driving the cost through their personality and their style of communication with the other side. Where every single letter is nasty, every single email is difficult. You can't reach basic agreements on how to move a case forward, right? Just because we're in litigation and cases going to trial, or we're going to hearings and the parties aren't seeing eye to eye, that doesn't mean that the lawyers need to be causing increased conflict and can't move the case forward efficiently, right? So we can have a nasty, drag out, month-long jury trial for all I care, which is extraordinarily expensive, but it shouldn't be added to the expense because the lawyers are too focused on sending crappy letters to each other, not agreeing to reasonable deadlines, not conferring on dates and deposition dates and trial dates and what have you. Right? There's a way of proceeding through litigation where you litigate your dispute, where you go to court and maybe you don't like each other, maybe don't see eye to eye, but doing it in an efficient way where it's not about the lawyers. It's about resolving the dispute. But it is very classic, particularly in family law, because it's a very emotional area of the law. and I get it. It takes a lot of practice. And I think back about some of the letters I used to write earlier in my career and cringe thinking about them. But it is very classic for clients to be paying for the divorce lawyers being unable to handle their emotions in the case, and letting their emotions get the best of them. And that doesn't serve the client well. It doesn't serve the court system well. And it makes things really, really expensive when we go about it that way.
Yeah, I think that's very, very, very true. Okay, well, that did go long, but hopefully informative for everybody. That's all we have for today. If you like what you heard today, do us a favor and leave a review. We appreciate all feedback, especially when it helps us better the podcast. If you have any questions or are interested in speaking to one of us about your divorce, just reach out to us at podcast@waltersgilbreath.com or just at waltersgilbreath.com. I am Brian Walters, joined by Jake Gilbreath. Thanks for listening.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreath.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreath.com. Thanks for listening. Until next time.